everyone. I'm attorney Donna DiMaggio Berger, and this is Take It to the Board, where we speak condo and HOA. Denise Lash is the founder of Lash Condo Law and has helped condominium clients in Ontario, Canada for over 25 years. Among more than a dozen other credentials, she's been the president of CAI Canada, the vice president of the Canadian Condominium Institute, and a director of Resilient Communities. She has appeared as a condominium expert in print, radio, and television. I've been extremely fortunate to get to know Denise during the pandemic when we appeared on several associate webinars together. Denise, welcome to Take It to the Board.
Hey, thank you, Donna. It's a pleasure to be here.
I am so excited to have you on. You are the first international guest on Take It to the Board because you are speaking to me from your home in Ontario, Canada.
You know, it's funny that you mention that because I am a U.S. citizen and a Canadian. I was born in Long Island, New York.
I did not know that.
Yes, I've been living and practicing law as a condominium lawyer in Toronto for many, many years. So all those 25 years I've been in Canada.
Well, I didn't live far. I grew up in Chicago, so I had friends in Toronto. I often say that I fell into the area of community association law when I had my first child. I changed law firms. I had been working in downtown Miami in a boutique banking law firm, and I wanted to stay a little closer to home after I had my son. And so I sort of fell into community association law. It certainly wasn't an area of law that I had thought about in law school. I don't know how many law students actually think about becoming a community association attorney. But I did, and it's basically been my life's work. So my first question to you is, how did you get on this path of representing community associations?
That's a great question. And I've been asked before, and I think you mentioned something which is really important for anyone listening to this, law students or anyone thinking of going into law school, to even be aware of this area of practice. So, I went to law school just like you. We didn't learn anything about condominium law. It was all about real estate. And as you know, Donna, acting for condominium associations, homeowner associations has nothing to really do with real estate law, although sometimes it touches on it. I was actually a real estate conveyancer. I used to do title searches. And then I went to law school and went back to the firm that I was a conveyancer for because they wanted me back there as an articling student. And they did practice condominium law for developers. And so I started learning about how to create those condominium documents. What ended up happening is sort of a long story, but the developer who was the client asked me to join him as in-house counsel. So I was working for a condominium developer's in-house legal counsel. Then after doing that for a couple of years, I decided I wanted to start my own law firm and have them as my main client. And when I did that, I had reached out to other lawyers in other condominium practice groups. And that's when I met a lawyer who did development work, but also condo association work. And he asked me, do you want to merge your practice and come over and join me and do both areas? And I said, well, I don't know anything about condo association law. He goes, well, why don't you try it? And you know what? When he introduced me to what that was all about, and I met board members and I attended my first owners meeting, I fell in love with it. I think it takes maybe a certain personality because not all lawyers like this area if they do try to practice in it. But I loved it. And I sort of moved.
You have to like people, right? Because this is a real people relationship. You're dealing hand in hand with the boards. You're helping them with short-term and long-term strategic planning. And, dealing with developers. And by the way, it's an interesting path because I did that once upon a time too. And now you're probably like me. I grumble about some of the developer documents I see dealing with post-transition boards.
Yeah, well, see, that's great. And I want to say I still act for developers and I think I'm one of the few attorneys here that does both because sometimes there's a conflict, but I keep them pretty separate. And it's really, I think just like you have the experience of drafting these documents. So when an association, a board will ask me and come to me and say, we're looking at an attorney, do you act for developers? Because we don't want a developer lawyer. And I say, I do. And I think you're better off using me because I know how to deal with developers. I know how to prepare condo docs. And it's worked very well.
It's funny, Denise, with all your credentials, I'm surprised I didn't find adjunct professor of condo law on your bio.
At one point I was doing, a television show, and I started a trade show about 15 years ago. And I thought that was the direction. So, everything condo, but no, there's just a limit as to how much condo you can do in your life.
I agree. You need a balance. You need some hobbies. But you touched on something important. I don't know if you get this kind of pushback from colleagues who practice in different areas of law, but representing associations can seem fairly uncomplicated to the uninitiated. So I've had colleagues ask, well, isn't it all about overweight dogs and contentious board meetings? But the reality is our practice does touch on land use and zoning, real property law with the easements, intellectual property, labor law. Shoot, we've even had some criminal law issues pop up. So have you found the public perception of what it means to be a community association lawyer different from the reality?
Yeah, exactly. When people ask me, what do? I say, I'm a condominium lawyer. And again, they say, oh, you practice real estate. And I say, no. Oh, you do closings. You close condominium purchases and sale. No, I don't do that. And I have to explain to them, I start with the basics. When a condominium association or corporation is formed, it's a corporation and there's a board of directors and they retain legal counsel. So I have to explain it. But, most people these days either own a condo or bought a condo. So they're starting to become more familiar with condominium corporations, associations. What are they? Then they sort of have an understanding, and I don't have to get into that much detail explaining what I do.
What do you do when you're at the board meeting? And listen, I'm sure you've had some contentious board meetings in your lengthy career. What do you do when the member stands up and says, don't you work for me? I am a member of this association. Who are you representing there? Are you representing the board or are you representing the owners?
That's a really important question. And, when I go to annual general meetings, I always hear the auditor say, I am here for you as owners, representing the owners. I don't represent the board. It's the same with legal counsel. Although, we take instructions from the board because the board's elected by the owners. But really, the board should be acting in accordance with our legislation as the Condominium Act and to act in the interests of the owners. So we will take instructions from the board as a whole, but this is where, if the board is asking me to do something that I feel that I cannot do or I don't agree with, I will refuse to do it. And if it means that I have to fire the client, then I'll do that as well.
But that comes from experience. So my experience is that younger attorneys who don't yet know when they're being, for lack of a better word, played by a particular board member with a specific agenda may head down a path thinking that the instruction they've been given is something that the entire board wants, only to learn later that this is really just an issue for that particular board member, usually the president. But like you, I think the more time we've spent representing associations, we can really spot that quickly and say, I need to hear from the whole board that this is the direction you want to go in.
Yeah, and that's something that we've gotten better at as a group at our firm. When we're retained, we make sure that we get a board resolution. When a director calls us, we don't take the call unless we had a specific resolution that authorizes the president of the board to call us. Because what's happened? We've gotten caught where different directors are calling us. Nobody's going to pay our bill.
Right.
So you've got to be really careful. So that's how we usually deal with that.
Well, I was going to geek out a little bit with you on onboarding clients. We have the same thing at Becker. We have an authorized contact list for just that reason. One, we don't want redundant requests. We also don't want conflicting requests. And yes, we actually do expect to be paid for the time we put into answering your legal questions. How else do you onboard clients? What do you want to know about a new client when they come to you?
First of all, and this is something that we do as a group, is we need to see their condominium documentation. And also, I ask them what some of their current issues are. We try to get to know the client in order for us to know how to give them proper advice. Other than that, we're really relying on the board and maybe management to tell us what their ongoing issues are. And, when we do our initial review of the documentation, then we will come up with recommendations. But other than that, I don't think we really go further. It's hard to know a client until you start working with them.
So does it ever surprise you that the things that the clients don't tell you? For example, We just started about a year and a half ago using a new client survey. And I started thinking about all the things that my clients didn't tell me until after they happened. Okay. Dispute, they turned down somebody. One big one that I had put in a year and a half ago was, is there new construction going up next door? Can't tell you how many clients would not think to even mention that issue to counsel. We ask, are you currently in a dispute with a vendor? Are you looking to take out a line of credit or a loan? Are you looking to amend your documents? Does it surprise you sometimes the important things that clients don't actually pick up the phone or send you an email about?
You've raised an important point, but also I like what you do. I think I may start doing that survey.
I'll send you the template.
Yeah, you just have to be more proactive. Sometimes the clients come to us after they've signed the agreements. And at that point, they say, oh, here's the agreement. Can you just review it? And I say, well, you signed it already. Well, just let us know if there's anything in there of concern. Well, it's too late.
It's almost like saying, tell us how bad of a deal we made. I also find that unusual for a client to say, review it after the fact, because it's almost like, if we have to tell you very bad news, you made a very bad deal, you've already signed it.
Yeah. And especially with construction contracts, sometimes it's come to us too late. And we have successfully gone back to the contractor in certain circumstances, but it's difficult to do that. And the other thing is where clients just think, we don't need legal, we don't need the lawyer to review this. I'm sure we could just do it. And maybe the manager is saying, I think you do. And they're saying, well, we don't want to spend legal fees. And then they go ahead and they do something without getting professional advice.
There's an awful lot of pressure on managers to step into the shoes of lawyers because they figure we're already paying the manager. So let's see if we can use him or her to do this. When in fact, they really need to pick up the phone. I always say, if the question starts, is there liability if? That's legal. That's a legal question. That is not a question for managers. I try to encourage managers to push back against that kind of pressure, but they want to keep their clients happy as well.
Yeah. And I think that's all of us are that way, right? We all try to keep our clients happy. We've got sometimes very difficult board members to deal with. And so that's one of the challenges I find, that we don't just practice law, we deal with personalities. And it takes a certain person to be able to deal with other people. And it's not for everyone, but, it can be challenging and it can be rewarding at the same time.
There's a lot of education that goes into this. And, listen, people volunteer, they get on the board. A lot of them want to do a good job, but nobody really sits them down and says, here's the role, here's what's been done. There's very little of, in terms of onboarding directors from other directors saying, welcome to the board. And here's what we're doing. Here's what we've done. Here's where we're headed. And here's what your specific role is. I know at your firm, Denise, you do a lot of education. Now in Florida, our board members have to be certified to serve on a community association board. And they do that one of two ways. They either have to sign a statutory statement that says that they have read, understand, and agree to uphold the governing documents, or they've attended a state certified education class. Like we taught before the pandemic, we taught 300 of those classes statewide. We moved them onto an online platform during the pandemic. So my first question is to you with regard to education. Do board members in Ontario or anywhere in Canada have to be certified?
Well, I can only speak to Ontario. In 2017, there were some amendments to our legislation, the Condominium Act. It established the Condominium Authority of Ontario, which looks after our public registry of all our condominium corporations, but also directors' education. So for the first time, 2017, we now have mandatory directors courses, and it is an online 21 module. And, I did it. Anyone can take it. It took me about an hour and a half to do the 21 modules, but I'm sure if you don't know the Condominium Act, it'll take you longer. And it's required. If you don't take it within 6 months of your election onto the board, then you're automatically disqualified. And the Condominium Authority keeps tabs on that. And so they will have a record that the director is disqualified. So it's something that's new. I just recently wrote a blog post, I think it was last week, on this. I don't think that's enough. And I think most of us would agree that being on the board and directors that have really limited experience sometimes shouldn't be making the decisions that they do. And I'm all for getting third parties and paying those third parties to act as directors and run the condominium corporation as a corporation. If we are going to have directors do this, the 21 modules is a good start, but I think we need a lot more.
Is it free, or do they charge for those 21 modules?
It is free.
Okay. So what's the pushback you've heard? Because normally we hear if we want to put any sort of qualifications to serve on the board, the pushback is typically no one will serve on the board. Was that the same in your market, Denise? That people said, "Oh, if we have to take a class for an hour and a half, we're not going to get people to serve on the board."
Yeah, but you know what? They've adopted it. And I think the way it's been pitched, like I sometimes will chair an AGM in which, they're having difficulty getting people to sit on the boards. So I don't pitch the 21 modules as a 21 module course. I just say, oh, there's this online course that you have to take, and I'm sure you could complete it in a couple hours. And it hasn't been a problem. And there have been cases where directors are disqualified and then they go and they take the course because many don't even know that they have to do it.
We have the same thing here, 90 days to be certified or you're off the board. But like you, I write a blog, and I will tell you the only blog post I ever wrote that received hate mail was my suggestion that we have mandatory board service. And it was really tongue in cheek, Denise. It was really, I was being a little humorous or trying to be humorous to say, we should treat board service like jury service. Your number comes up, you have to serve on the board. And people said, are you crazy?
But I never thought of that.
Obviously, just like with jury service, there would be ways to get out of it if you couldn't serve on the board. But a lot of the issues we see with board elections is what? People saying, I was kept off the board because of, whatever, I'm not liked, or this board stays in place. So if there was a mandatory type of service where, look, everybody's going to serve on the board eventually because your number's going to come up unless I was saying it tongue in cheek, but I still remember that as we're having this conversation, that it's a very emotional topic in terms of who serves on the board, how long they serve on the board, and whether or not they're qualified to serve on the board.
Yeah, I know. I mean, that's my only concern is that I've seen some directors that really should not be directors making the decision. So, if everyone takes their turn as a board member, it's heading for disaster. I sort of like the concept though. But, in Ontario, most corporations have 3-year terms. The Condominium Act says no greater than 3-year terms. But, you can continue on, just be reelected every 3 years and then just serve for many, many years. And I've known directors who have served for, the length of term I've been practicing, and they're great directors. And then I have the other ones who are pretty much dictators, and there's concern with them sitting on the board and maintaining control through, the use of their proxies. So I've seen both, and it could be good and it could be bad. I think if you limited the terms in certain associations, it may be difficult to get people on the board.
We did that down here. So a few years back, we went back and forth. It's a term limit of 8 consecutive years. Okay, so you could get off after 8 years and then skip a year and get back on. Or if you don't have more people running than seats available, if the director gets 2/3 approval, they can stay on longer. Again, it's very hard when you're trying to craft a legislative solution to a problem, because often you create more problems than solutions. And in Florida, I think the feeling was we have people that get on these boards, as you said, possibly dictators. They're keeping other people off. The longest running person in one of my board cert classes, Denise, was a very tiny old lady, and she had served 40 years. But she was darling. She was a really nice lady. And somebody like her, she just kept getting elected because everybody thought she was doing a great job. Now, we do have other instances where you have board members, and it does create a problem if they won't get off, and you do need some fresh blood. I'm sure you're seeing it too. We have very divergent opinions in a lot of our communities now. We've got people in their 70s, 80s, and 90s, and people in their 20s, 30s, and 40s, and there's different perspectives on reserve funding. There's different perspectives on on alterations and improvement projects. And those kind of generational gaps are reflected and really, I think, reinforced by who's serving on the board. If you have a board that's comprised almost entirely of people of one generation making decisions for a populace that's a different generation, I think that creates some stress points.
Yeah, so I don't know what the solution is. I mean, because you have that new requirement, or I guess it's not so new, that they have to get off the board after 8 years. Does that help?
I think what's happened is they just keep getting the 2/3. It hasn't really been a problem yet because it's only been they went back and forth, but we just had legislation last year that confirmed that it's only in effect going forward as of 2018. So we haven't really hit that 8-year mark yet. Well, I guess it remains to be seen if it's going to hurt or help. I think it's probably going to have little impact.
I mean, the whole nature of being on a board and the personalities and having a dysfunctional board, those are, from a legal perspective, really difficult. They've been very challenging for me and the rest of our team. When you have a great board that can work together, where they're making wise decisions, you've got a healthy community. But then, when things start going sideways, where you're getting these board members that just can't make a decision, you've got a split board, the community just goes down from there.
With all your experience, what do you think the number one mistake is that most boards make?
Sometimes I'm dealing with a board where they have no involvement whatsoever, and they leave everything to the manager. And I say, well, that's dangerous. I mean, you don't want to micromanage, because that's another issue where they're too involved. So where's the happy medium? Let the manager do the management, but you need to be involved. Otherwise, there's certain liabilities there.
Well, certain duties just cannot be delegated.
Yeah.
You cannot just, shuffle it off onto your manager. I've seen that as well. This is going to sound self-serving. Well, I can't limit it to one mistake. So I'm sorry. It was an unfair question to you, Denise, because I can't limit it to one mistake. The self-serving answer is, I think, too many boards don't reach out and hire professional advisors. They think they could do it on their own. They've got the retired, personal injury attorney on the board, the retired accountant on the board, the retired engineer on the board. And they think, why spend the money for these professionals? Let's just do it ourselves. That, I think, is a huge mistake. There's no safety net. They're flying without a safety net of any sort. And then secondly, I think the other big, huge mistake that boards make is they don't communicate often enough through a variety of channels. And I'm going to ask you about technology in a few minutes, but you have to speak to people in the ways they want to be spoken to, whether that's, an email, a text, on an association website, at more frequent meetings. I think those are the two huge mistakes I see, that they don't reach out. They don't want to spend the money to hire a professional advisor, so they rely on input from just the board members. And secondly, that they're not communicating often enough and in the channels that actually resonate with their owners and their residents.
Yeah, I mean, I think that's the number one complaint from owners when we go to these meetings and they're saying there's no transparency. We don't know what the board is doing. But then again, the board members are volunteer board members. They're dealing with so many issues usually. And then the owners complain about, well, you haven't advised us. You haven't communicated. Well, will certain owners volunteer? What about those owners that are complaining? Why aren't they in charge of the communications committee? But I agree. I think, that is sort of the number one complaint that I hear from owners, is that the board's lack of transparency.
I imagine your legal market, I shouldn't imagine, I should ask you, is your legal market highly competitive when it comes to this area of the law?
Well, I was going to say there are so many condominiums that are being built in Toronto in particular, in Ontario, I think, and there aren't that many condominium law firms. And I've been speaking to some law students and saying, if you want to get into a great area of law, specialize. And if you're going to specialize, condominium law is the area to get into now. I don't think we have enough lawyers. Yes, we have competitors, but there's enough work for everybody. And, I'll be honest, we get in probably 2 to 3 new clients a week, like lately, because of the number of developments. And, we're sort of a smaller firm. It's a lot. I mean, we're up to probably around close to 700 associations, and there's not that many of us.
And I almost fell off my chair. You said you don't have enough lawyers that are representing condo associations in
I don't
Ontario.
think so. I don't
Can
think
we
so.
send you some?
Yeah.
We have quite a few. So as you might imagine, the Florida market is highly competitive. We've got big firms that have decided that they're going to get into this, mostly on the developer end, but sometimes even the large firms are deciding. There's so many community associations. We have about 60,000 in the state of Florida, so it absolutely makes sense to offer services to those post-transition. For people listening, that transition is when a community moves from developer control to the developer selling out and the owners taking control of the board. But we also have a lot of small shops opening up. And again, people that, right out of law school that might think, okay, I'm going to start representing associations. But as we said earlier, Denise, this is a fairly nuanced, complicated area of the law. It's not just about going to board meetings and listening to people squabble over the budget. It can get very complicated. There's a lot of regulations. In Florida, at least, we are seeing a lot of legislation every year. We're guaranteed to see community association legislation pass. And that, of course, necessitates changes operationally and in terms of changing documents sometimes to keep up with this constant stream of new legislation geared to regulate community associations. Are you starting to see that in Ontario as well?
We've had many changes with our legislation, and not just the Condominium Act, but other legislation that impacts on condominiums. But, I want to go back to your 60,000. I just can't believe it. How many associations that you have in the state of Florida. In Ontario, I think right now we're about 12,000. But, we are condominium corporations. We don't have homeowner associations here and those gated communities like you have in the state of Florida. So it's a little bit different.
Yeah, most of the new housing that's going up around the United States is inside a mandatory community association, either a condo or homeowners associations. We're not finding a lot of new developments that are outside that framework.
So, we have some co-ownerships and some co-ops, which are, the share structure. But other than that, it's mostly condominium corporations in Ontario.
So I want to circle back to what you said a little while ago. So many lawyers and law firms are focused on bringing in new clients. Of course, that makes sense. We're in the business of providing legal representation, and you want to offer those services to as many clients as possible. But there are times when you need to say goodbye to a client. So what is your philosophy on disengaging a client?
It's been really difficult for me because, of course, I don't like to see a client go. And it doesn't happen that often. I think I mentioned before where a client won't follow our advice or will ask me or one of our other lawyers to do something that we won't do. Or, sometimes it's just a very difficult client that I have to make a decision that it's just not worth having that client as a client. It just sucks all the energy from you. Or, there are other disrespectful clients. And I'm concerned about our associates, our lawyers here. Having our lawyers here long-term really means a lot to me and, the growth of our firm. So we're not going to take that abuse either. It doesn't happen that often. I think, maybe twice that I've had to terminate a client.
Well, listen, it is tough because you work hard to bring in clients. And as we said at the outset, this is a personal relationship. We spend a lot of time talking to these board members. We work through so many of their issues, particularly a client that you get post-transition and may represent for years and years. You see them through a lot of different challenges, and it's a really personal thing. But I agree, abusive communications towards your staff, not communicating well, perhaps operating outside the framework of the statutory regulations. All of those are troubling. I have not personally disengaged that many clients. I will tell you, I did disengage two that I wound up taking back because they said, you know what, you were right. And there was a lot of dysfunction on the board. And, I always leave the door open. But at that point, we just couldn't work productively because they weren't working productively. And they cleaned up their act. And I'm happy to say those are pretty healthy communities right now.
Yeah, it's funny you mentioned that. I just remembered, what's happening because I've been practicing for so many years. There are clients that I represented 20 years ago, and some of them I really had a great relationship with, but the boards were removed. And sometimes when the boards are removed, they terminate legal counsel. And so we left at that time because it was a whole new board, new legal counsel. And now they're come back after all these years saying, we want you back. We heard that you used to represent us, 20 years ago. It's really a strange feeling, but it's rewarding in a way.
Yeah, it's a nice feeling, isn't it?
Yeah, they're all coming back.
They can't get over you.
Yeah, it took them, 15, 20 years, but they soon realized,
the error of their ways. So Denise, we met during the pandemic. Early on, Associate brought us together with Sandra Gottlieb in LA, who's fantastic. And we did a couple webinars together, and I was so impressed with you. And that's why I was so happy to have you on the podcast. You were unique in terms of your situation because you had experienced the SARS outbreak back in, I think it was 2003, correct? So you'd had a little brush with this kind of an issue. Did that help at all in coping with COVID-19? And how are your communities doing now?
You know what? It didn't really help in terms of, us providing advice to our clients. I think, it was a whole other thing. SARS was a very different kind of pandemic. It's not like COVID at all. When, that some of the stats, I think there were 44 deaths and around 250 cases of SARS in Ontario. In Canada, mostly it was in Ontario. So what happened from that, I think, is the government, and they started agencies to deal with it. And so as a whole, our government was more prepared for COVID and for the current pandemic, just because the agencies were established back then. But in terms of condominiums, you see that this is so different. I think because there's so many people that, when you don't know when someone may be tested positive for COVID and SARS, when you were ill, you knew you were ill. And so there was a way to deal with it just because visually you could see it. So totally different thing. Were we better prepared than, the state of Florida? No way. We are following what you're doing there and taking that back and recommending certain steps be taken. All the privacy issues, safety protocols and following public health guidelines. This is all new. So it didn't really help us. It helped the government get things in place. But other than that,
have you had any legislation, Denise, that would shield your volunteer board members from COVID-19 related damage claims, personal injury, wrongful death claims?
Yeah, similar to, I think, what you have in the state of Florida. We do have something similar, so I think that's how, when we base our advice, we say, follow public health guidelines and sometimes be more restrictive, just in terms of liability.
What are the main issues your client communities are grappling with right now?
Well, it's the vaccination issue. Do you need proof of vaccination? The privacy issues around that, opening the amenities, because now we're in our stage 3, which is, more gatherings are allowed, indoor dining, gyms are now allowed. So now they're coming to us. Should we allow gyms? Should we ask for vaccinations to use the gym? And so lately, we're just trying to figure out creative ways of dealing with things. We don't know. And again, this is a challenge for us, trying to come up with the good advice for our clients. And on the vaccination issue, we've now come up with a suggestion that only double vaccinated residents can use the gym at a certain time. It will be the vaccination resident time. And that if a resident doesn't have proof that they've been vaccinated, they can't use the gym during that particular time.
Yeah,
so these are the things. Have you been doing something like that?
Yeah. Not forcing the issue, but certainly giving certain liberties, again, in accordance with public health guidance, that fully vaccinated people can go mask-free indoors if they want to provide proof of full vaccination. So not requiring it, just a different set of rules, basically, if you want to provide that proof or if you're not willing to.
Yeah. So I think the main questions now are COVID related. And then the other thing is all the issues around meetings, virtual meetings. And we're spending a lot of time, I used to be asked to chair AGMs during our busy time, maybe once, twice a week at most. And there are a couple of lawyers that could handle that. Now with these virtual meetings, we have all of our lawyers doing virtual meetings almost every single night. We've never done so many, and we're chairing them because our clients don't feel comfortable chairing a virtual meeting. And that's one of the reasons I started a workshop through CAI, and we do certifications of chairing of virtual chairs just to try to get our clients trained on knowing how to chair a virtual meeting.
So are you loving the virtual meetings though?
Well,
you don't have to drive.
Okay, Donna, I'm loving it because, well, you know what? I don't know when you had started or when. I know you have your BP ballot, or is it called
It's
BP
Becker,
ballot?
it's Becker ballot now.
So I think it was many years ago
Yeah.
called and so our legislation in 2017 was amended to allow electronic voting. And in 2017, I noticed that in the legislation and nobody else picked up on it in Ontario. And so I actually went and researched and looked at what you had done. And the state of Florida then brought electronic voting to Ontario. This is before the pandemic, and was trying to promote it and telling clients and the industry, here's a new way of voting. Let's get away from these proxies that we're dealing with. You know, there's a lot of litigation that we've had on proxy fraud. And so I thought it was great. Electronic voting seems to work well in the state of Florida and other U.S. states and Texas and Arizona. And so it was a real challenge. A lot of condo attorneys said that they thought advanced voting was illegal. The whole concept of virtual meetings, they thought shouldn't be permitted. And then we have the pandemic.
But I was going to say that was prescient of you because, the people who had the online voting already in place when the pandemic hit, it was seamless for them. Of course, you have to also give out the paper voting materials to people who do not opt in for online voting. But for my communities that didn't have online voting, they did the virtual meeting, but they were still, this is in the early days when there were so many concerns about transmission on surfaces. So they had the face shields, the gloves. It was, it was like they were dealing with medical waste almost with these paper ballots and proxies.
I know. So it's been amazing. And that's when I partnered with some tech guys and launched Condo Voter and doing the virtual meetings and the electronic voting. And it's been a real learning experience for a lot of, for directors and for managers, but the managers are loving it. Because think about, no more in-person registration. Dealing with proxies is a bit of a challenge. I think that because this is all new, nobody is really sure how do you deal with paper proxies in a virtual meeting. And so there's been different service providers doing it different ways. I am trying to form a movement called the abolition of the proxies. So the abolition movement of proxies. If you ever look online, sometimes I do polls on these proxies and trying to get people on board. But there's one attorney in particular who is a pro proxy. So he and I have been going back and forth on the internet about that.
Well, if you're like what our problems are, we have a lot of units and properties that are owned by business entities, LLCs, for example. And so if we're dealing with the paper voting materials, a proxy, in Florida, our election materials are anonymous. I don't know if that's the same in Ontario, but it's anonymous. We cannot know who's voting for whom in the election. But if it's an LLC, there's a lot of judgment calls. So you get that outer envelope, which has to be signed by the unit owner, and the unit owner is an LLC, and the signature doesn't look like, we can't even tell who this is, or if they haven't printed their name. And so there's so many judgment calls. I mean, I remember, Denise, being in my larger communities, my communities with 350 or more units, we would start the meeting at 8. I had one meeting, we didn't leave until 1:30 in the morning, because of all those judgment calls on the paper voting materials. Now, with online voting, it's calculated. But you mentioned that some people are pushing back. Now, let me guess. Is it because they think it's vulnerable to fraud somehow on the online vote?
That's been one. But I think what they're saying is the older population, and I don't agree with that, but the older population, they're used to paper proxies and they can't do online. Well, Condo Voter, because of that, they're doing telephone voting. So actually you could vote by telephone and it automatically goes into the electronic voting system.
Oh,
You can do
that's
both.
interesting.
Yeah, so you can vote.
Although I would say if you can do Facebook to look at your grandkids, you can do online voting. If you've
Yeah,
got the right platform, it's that easy.
I know, but there's still that pushback. I've heard all those arguments, and then, they say, well, I want somebody else to attend the meeting. So I'm saying, okay, attend virtually. Well, I guess you could pass the link on to somebody else. You could register yourself. Like the whole argument for why we need a proxy just doesn't make sense to me. I think owner direct voting is the way to go. And the proxy, and when you even talk about the paper, think about all the costs to condominiums that have had to pay for their attorneys for these longer meetings or the registration process just to determine the validity of the documentation.
Yeah, in my opinion, the paper proxy is more vulnerable to potential fraud and abuse than an online vote. Because again, unless you have a handwriting analyst on staff, you could conceivably forge somebody else's signature. So, in my opinion, or proxies can go, ballots, for instance, can go missing. And if you use a ballot box and it's coming in, ballots can go missing because again in Florida they're anonymous, and I think you indicated that's the same for Ontario in terms of your elections.
Yeah. So now we're looking at hybrid meetings because owners are now want to go in person, and some people like the in person. It's a sense of community, and so we're looking at developing ways like a polling station, where instead of the paper ballot, you come into your meeting and you go over to the station. You can vote on an iPad. So
Well, that I
try to
love
do
that
away,
idea. I love that
do
idea.
away with paper, right?
So sit in the meeting, take out your phone or your smartphone or your iPad, cast your vote right there.
Right. And if you can't, because you don't have one, then you could have a polling station, or management can have something at the front. So we're looking at developing that through the hybrid meeting. And then also, we've gotten such great participation from off-site owners that you never had their participation before. Keeping that and having the virtual component as well as the in-person, hopefully you could develop something that's that's more cost effective, because you don't want to do two meetings, right?
Right. Oh, absolutely not. So, what other technologies are you exploring? It sounds like you are the person who brought online voting to Ontario, Canada.
Yeah, we're just looking at all kinds of things. So in Ontario, we have these in our legislation. The reason that I'm so passionate about getting rid of the proxy is we have a mandated proxy form that's 6 pages long. And that was developed in 2017, and it went through other changes because it became so complicated. But even the changed proxy form is even more complicated. And there's actually a guide to completing a proxy.
I mean, there's something wrong if you need a guide to be able to complete a vote.
So what we find is a lot of the proxies that are completed are invalid anyway. So that's why it just doesn't make sense. So in terms of technology, now that or most people are liking the virtual way, but want the option of coming in, we're looking at registration being more automated. So you know how managers usually sit at the front and check off, and well, no more. It's going to be online. So integrate with the virtual online attendance and the in-person attendance.
I'm learning from you. I'm taking I'm going to take some of these tips and use them down here too. I love it.
Well, yeah. So we should talk, because there's we have a lot of ideas that we're developing.
Well, listen, in Florida, one of our big issues is obviously our 6-month hurricane season. So we're trying to figure out how can we utilize technology, whether it's group text to when there's a warning, communications about evacuating the building if a storm's approaching, group communications on when it's safe to come back into the community after the storm has passed. So given our geographic vulnerability here in Florida, we're trying to think of other ways we can use technology to contend with our hurricane season down here. So I'll keep you posted. You don't have hurricanes in Ontario, but you've got other stuff.
No.
Given the changing weather patterns that we're seeing, I think figuring out how to use technology in terms of these weather events and these the wildfires, the earthquakes, the hurricanes, the tornadoes. How can we use technology where we can get word out to people immediately to keep them safe? I think it's something we're going to have to brainstorm on.
Yeah, and I think that we're finding a lot of the corporations, especially the newer ones, they all have that technology built right in. So it's part of the security protocol that they have. They have the online, those service providers that provide that full service online support for, various things like booking amenities or notifications of maintenance and repairs, those kinds of things.
So it's a good idea for existing communities to kind of keep an eye out for what the newer communities are providing. It helps them stay competitive. And like you said, the newer communities are coming out with a lot of this technology. There's no reason that longstanding communities can't incorporate some of that technology into their operations.
Yeah, I mean, things are changing, like, our deliveries are, and all the challenges of having all the Amazon boxes. There's service providers that are now providing storage facilities on site. So, as things evolve, and we have to develop ways of dealing with it.
So last question. How do we get the next generation of young attorneys interested in this area of the law?
Well, I am fortunate that I have quite a few millennials working with me. And, one was actually a daughter of a manager and went to law school. So the manager approached me and said, what do you think my daughter working with you? That was great. There was one of the law schools had reached out to me, and I did a podcast about this area of law. And it's really spreading the word about what this all means. I'm ready with my the next generation in my firm. So I think it's a great opportunity. I love it. And, Donna, you're so involved with media and, and you teach and, all of these interesting parts of this practice of law, which I really love. So, I'm at this point now where the media calls and I hand it over to one of our associates and say, you do it.
Well, that's great. And listen, this particular area of law is recession proof for the most part when you think about it. So unlike other areas, back in 2006 through 2008, they got hit hard. Those areas of the law, particularly the real estate development, which went down. But associations, they exist in good times or bad times. They're still going to exist. Their focus will change, but they still need legal help. So in many ways, I think this area of law is a very rewarding area of law. I also think it's a very safe area of law in terms of having a consistent need and consistent client need out there.
I agree. And you've really hit the nail on the head, which is recession proof. And that's something that I think my mentor said to me many years ago, 25 years ago. Yeah. He said, that's what's great about this. When I was doing both development and condo association law, he said, that's, condo association is recession proof.
Well, Denise, as always, it's been a pleasure speaking to you. Thank you for taking the time to share your wisdom and insight with our listeners. And I hope I can get you back on the show sometime.
Oh, Donna, it was a real pleasure. And I'll continue to follow you and what you've been doing for your community.
Thanks for joining us today. Don't forget to follow us on your favorite podcast platform. Leave a review so more people can take it to the board. And visit takeittotheboard.com for more information. For more information.